And so, therefore, it's sort of analogous to mandatory pretrial detention statutes, where Congress says if you, as a prosecutor, determine that you're going to go after somebody, you're going to prosecute them in the criminal realm, there are certain people you have to detain during the prosecution. There are certain, people who've been convicted of certain crimes. We have statutes where Congress says those people have to be detained, but that doesn't speak to the antecedent determination of whether or not to prosecute those people. I think the problem that I'm seeing with the state's argument is that they appear to be conflating Congress's mandates with respect to detention and Congress's statements with respect to removal, and that the idea of 1226C is that once the determination has been made pursuant to prosecutorial discretion that you're going to remove someone, if those people fall into the particular criminal alien categories, they have to be detained for the purpose of that removal. Am I reading that correctly?
Yes. So the way that DHS has long understood and implemented this provision is that if we have a non-citizen in custody with pending removal proceedings, as 1226A requires, then if the non-citizen is described in 1226C, detention is mandatory. And the reason for that is not because it says shall detain. We don't think that that bare use of shall alone displaces enforcement discretion. It's because in 1226C2, Congress specifically delineated the permissible bases for release and said the Secretary may release only for narrow witness protection purposes. And isn't
it also related to sort of conceptions of government power? In other words, the reason why you have the authority to detain someone is because you've made the determination that they're going to be removed. The government doesn't just go around detaining people without having made a determination about their prosecutorial ability, without the fact that they're going to prosecute these people or they're going to remove these people. That's where the authority comes from.
Yes,
right?
And I think that this relates both to the colloquy that I was having with Justice Sotomayor and with Justice Kavanaugh. It would be a really extraordinary thing for Congress to have dictated to the executive that it has to seek out, identify, apprehend, and remove as an inflexible mandate each and every non-citizen who's described in a provision that uses the word shall in the INA.
Is that true?